Good evening and welcome to everyone. And I'm excited to have you here for a special Spotlight PA event, member only event on the federal courts. As I was just talking now, I see many of our wonderful committed supporters here this evening. I see some new folks who joined us so they could attend this event. So, right off the top, I don't want to waste any time in acknowledging and appreciating that support. You make everything we do possible. That is not an exaggeration, it is the truth. We exist to serve you, and we can only do that together with you. So, we really appreciate your support. Celebrating 5 years of impact since launch, Spotlight PA has not only changed laws, but it has changed lives in communities all across the Commonwealth. Our deep, insightful reporting seeks to return the power of the press to its rightful owners, not big corporation shareholders, hedge funds, but to you, the people. And that's what Spotlight PA is really all about. As you have surely noticed, federal judges have been thrust into the center of our nation's politics as courts across the country have been flooded with challenges to changes by President Donald Trump's administration, and as some Republicans have advocated for defying rulings or for impeachment. At the same time, the attention has sparked debate and conversation over whether federal judges should have the power to issue nationwide injunctions over executive branch policies. And yet, with all of this in the news and so much talk and chatter all of a sudden about the federal courts, most people don't actually fully understand how the federal court system works, the nuances of how it's run, and why its independence isn't really a political issue of left and right, but truly the independence of the courts is in everyone's best interest. And that can easily be stated by the fact that on any given day, one of us may end up there. And I think we would all agree that we want a fair shake. And so that's why judicial independence is in everyone's interest. We are honored tonight to be joined by our own and Carlisle's own Mary France. Mary served from 2003 to 2017 as a federal bankruptcy judge for the United States Bankruptcy Court in the Middle District of Pennsylvania. In addition, she served as the assistant U.S. trustee in the Middle District, and in that role, she lectured frequently on the role of the U.S. trustee in the administration of bankruptcy cases. Mary also happens to be a passionate supporter of Spotlight PA, so it's my double pleasure to welcome her here tonight. Welcome, Mary.
Really happy to be here, Chris. I
Great.
very much support Spotlight and anything I can do to help, I want to do.
Great. Before we dive in, I do want to plant one seed because I would be punished later if I did not. If you value the discussion, if at any point it gets the mind going, stimulates your thinking, gets you thinking, we invite you to consider extending your support of Spotlight PA. And I say that because from now until midnight Saturday, as part of our spring member drive, any gifts you make will be doubled. And so if you want to do that at any time during the event, afterwards, or not at all, totally up to you, spotlightpa.org/donate. Again, that's spotlightpa.org/donate. Also, want to point out that the title of tonight's event, Full Court Press, was a little homage to Mary because I know she's a huge college basketball fan. So she didn't know that that was part of the thinking of the title, but that was my little Easter egg to you. So let's dive in. Can you talk a little bit about how and why you became a federal judge? What was it about it that interested you and you were passionate about?
Well, it was a very circuitous route to becoming a judge. I grew up in a family with a father who was an elected judge in Florida, but I never considered being a judge. I had intended to be a teacher, and that didn't work out because of a lot of moves. And eventually, I decided to go to law school with the encouragement of people that I knew in the jobs I was working. And we moved from South Carolina to Pennsylvania and went to Penn State Dickinson, which was just Dickinson at that time. I started out with a law firm and I was doing family law, and I found I really disliked it a lot. Nobody was ever happy. So believe it or not, I found a much more satisfaction doing bankruptcy law, which nobody can believe. Everyone generally thinks that's very depressing. But it really wasn't because people were allowed to work things out and to get a fresh start. And I liked that aspect of it. I then spent 3 years at the Pennsylvania Department of Banking and was basically a regulator. And so when the U.S. Trustee's Office was looking for someone with a bankruptcy background and a regulatory background, I ended up over there. Nothing I planned. But after 10 years there, when Judge Robert Woodside passed away, and they were looking to replace a judge, a number of people encouraged me, and so I thought, okay, I'd throw my name into the ring, and the process. I'm an Article One judge. I'm not an Article Three, and the difference is that Article One judges, like magistrate judges and bankruptcy judges, are merit selected. Bankruptcy judges are selected by the Court of Appeals, where in the for the district where you'll be presiding, and the magistrate judges are selected by the district court. So it's a little different route that I had than judges that are named to the district court, the appellate court, and the Supreme Court. So
What
that's how I got here.
and and in all the time you spend, I sort of we're going to dive in, then we're going to walk back a little bit, but uh, I think people are curious, and we had some questions about this. What is right now? What is the most common misconception or misperception you think people have about the federal judicial system and the role of federal judges?
Well, I think this probably has been exacerbated more recently, but it has been my impression ever since when I was on the bench, and of course I've been off since 2017, and looking from the outside in now. I still think that it's like when you're watching an attorney show or a doctor show, you think they're in surgery if they're a doctor all the time, or you think that they are in a courtroom all the time. It's the same with judges. So much of what we do is defined by the Constitution, by the laws we interpret, by our rules of court, by our code of professional conduct. So we're much more circumscribed in what remedies we can offer than people tend to think you are either Solomon or Judge Judy, and we're neither. We're not gifted with divine wisdom necessarily, nor are we able to just look at two parties and know exactly what the answer is from the get-go. So I think people don't understand that we have far less discretion in a lot of what our decisions are. We're there to interpret the law. We're not there to have this freewheeling dispensing of justice.
And you mentioned sort of the current climate, and I wonder again from now looking from the outside, what feels different to you right now in terms of the climate and the news around the courts than maybe from the past or what you've experienced?
Well, there's always some tension between the other branches of government. The courts have to look to Congress to provide funding. Congress has, over the years, often wanted to make decisions about what types of activities would be permitted for judges. They wanted to audit them. That those sort of proposals came up. So there have been tensions like that for some time. Um, Less so with the executive branch that I was ever aware of. And I would say, I know we've one of the issues that's come up recently is the connection to the U.S. Marshal Service and being a component of the Department of Justice, so it's part of the executive department. we always had a great working relationship with the Marshal Service, and there are many times when I feel like my physical safety was preserved by actions by the U.S. Marshal. So I would never want to suggest that I thought that there was a problem in the way that they have operated. That was my experience. I think the problem now is that it's become so acrimonious, so personal, um, and we're hearing from quarters where you didn't usually hear very derogatory comments about judges, and that seems to be a new practice, a new approach that we didn't experience when I was on the bench. You would be criticized certainly, and but most people realized the appeals process was the way that you tried to correct an error. And if you had a different, I had many different opinions from other members, other judges, and I didn't think that they were bad people but because they had a different opinion from me. That seems to be one of the things that has occurred more recently, and it certainly made judges more concerned about their physical safety. Judges became more concerned when there were several attacks on judges, and the one district court judge whose mother was killed and husband a number of years ago, and they ramped up security after that. So we were much more sensitized to security issues, but these calls to attack judges, implying either physical or verbal, you don't know, seems to be at a much more heightened level. Yeah.
But just sort of take a step back for a second. We'll come back to some of those things you touched on, including there was a question about the Marshal Service and enforcing orders. But we'll come back there. Let's just level set for a few minutes. And can you just give us a brief understanding of the sort of tiered structure of the federal court system and how cases move between these levels?
There are 13 circuits in the United States, and they are divided into district. They have district courts within them, and we're like in the middle district. The district courts are the first level court. They're like the Court of Common Pleas in Pennsylvania. They deal with the many criminal matters that occur and that are occur under federal law, criminal prosecutions, and then of course they handle civil actions that are within the subject matter jurisdiction of the federal courts. Um, I don't know if you want me to, I could touch on subject matter jurisdiction while we're here. The state courts are courts of general jurisdiction. Most of the cases that occur are in the state courts, custody, juvenile law, probate. Most people will have connections or likely have connections with state court than with federal court. The district court then is the trial court, but the only cases that are heard in the federal courts are either federal question cases, meaning they arise under federal law. There's a statute or a constitutional issue, or they are under the court's diversity jurisdiction. And that also has a dollar limit. Like if someone from Georgia sues somebody from Florida, they may be able to have their case heard in federal court if the claim is above $75,000. So there are limits on what the district courts can hear, much more so than with state courts. If there is an adverse decision for a party, then they can appeal to the Court of Appeals. Um, the After the Court of Appeals renders a decision, the next level, of course, is the Supreme Court. The big difference there is that the courts of appeal, someone may take an appeal they want an appeal to go to the Supreme Court. But in order to get the Supreme Court to hear a case, the Supreme Court has to issue a writ of certiorari. And basically that's saying, I give you permission to file an appeal in the Supreme Court. Um, the Supreme Court may have 10,000 requests for uh, a writ of certiorari, but they only hear about 75 to 80 cases a year. So there are a lot of actions that are terminated at the Court of Appeals level. There's really that one appeal. So those are the levels. And then, of course, recently we've heard about some courts that are not within that three-tiered structure, in particular, the Court of International Claims, which is one of the courts that's outside of the usual, outside the 13 courts, courts of appeal and the district courts. And there are a few that handle specialized cases. The Court of Claims, if you have a claim against the federal government, that's also a specialized court like the Court of International Trade. And those cases go to a special appeals court. They also
And
may go to the Supreme Court.
I think uh, more so than usual, we've heard a lot about the various district courts and this idea of injunctions. We keep hearing in the news injunctions, injunctions.
Mm.
What are they? What should they be, etc. They're all over the news. They're part of the political discussion. Um, can you start by walking us through just like what is an injunction? What's the standard for them? Just sort of how they work.
Yeah, sure. There are basically three types of injunctions. One is a temporary restraining order. You'll hear TRO bandied about. That's a TRO. That is an injunction that can be issued by a court without even notice to the other side. So it's incredibly extraordinary relief. And basically, the argument that has to be made to the court is if you don't enjoin the other party now, there will be nothing to litigate tomorrow or the next day. They're coming over to chop down this 300-year-old tree in the park across the street. So they're saying we need to have a temporary restraining order now. Whether or not they should be allowed to cut down that tree, well, we can move ahead and decide that later, but I need a TRO right now. Preliminary injunctions and a TRO typically only lasts 14 days. So it's a very short term. And you pretty much have to get your pleadings in and file a request for a preliminary injunction uh, during that time period. The preliminary injunction does go out on notice to the other party, and there are pleadings filed and responsive briefs, and there may be affidavits, but it's still in a sense prejudging a case. It's deciding that something has to be stopped before you've had a full trial on the merits. And typically that requires like with a TRO, you have to be trying to maintain the status quo, and there's a chance of irreparable harm. Then, you also they balance the equities between the two parties, and then they look to see whether there's a public interest in issuing the injunction. But the probability that there would be irreparable harm and that the fact that the movement is likely to ultimately succeed. They look at the pleadings and see, are they ultimately going to be granted the relief? Then if those two standards are met, generally then the injunction will be granted. Then, of course, you have a permanent injunction, which would be after a complete trial that would say, no, you can never chop down that tree. You're not entitled to do that. And be the end of the matter there in terms of injunctive relief. So we've had a lot of cases in which both TROs and preliminary injunctions have been entered in the federal courts, uh, contesting the legality of actions in a variety of contexts that the uh, executive branch has initiated.
And there's been a lot of discussion and some political debate over the issue of injunctions from the district court level and the fact that they apply kind of everywhere, not just in that district or that circuit. Um, can you talk a little bit about just why that is, and why that, I don't know, what people should understand about that process, as it's because there's some debate now as to in Congress as to whether there should be some limitations on the scope of injunctions issued by, say, a district court.
Right. Well, this is a very difficult question, and legal scholars, experts disagree. There's a lot of disagreement on whether or not this should be permitted, and it's difficult to have a hard and fast rule on this issue. When they say nationwide injunctions, and there's if there's opposition to that, what they're getting to is the fact that parties are being enjoined that are not before the court. And typically, a lawsuit can only bind the parties that are in front of the court. In some of these cases, because the plaintiff is seeking to enjoin the federal government, uh, the executive and what action they're taking. What they're arguing is the same issues here in this particular case in, say, New Jersey, is the same issue that will be replicated all over the country. It would be horribly inefficient and would delay the granting of relief if you had to file this case, if someone had to file one in every district court or in many district courts. So I understand, I appreciate the argument about uh, entering judgment against parties that aren't before the court because that's something typically in the bankruptcy arena, we were often asked to enter injunctions against a creditor of a bankrupt debtor from going against the principals. That's what Purdue Pharma was all about, that eventually the Supreme Court said you cannot uh, you cannot provide an injunction that protects the owners of Purdue Pharma because they are not before the court. So that kind of precedent makes it really a difficult issue to know where the Supreme Court might land. On the other hand, if they ban that completely, the multiplicity of lawsuits would be astounding. Yeah.
I want to touch back real quick to the structure we talked about and just ask, within that structure, are all districts and particularly all circuits created equal, or because of the location and oversight of some, might we hear more about some or read that some seem to have more, I don't know, I don't want to say power, but like are more prominent among the circuits than others?
Well, yes, and a lot of it's to do with things like population. In the Ninth Circuit, where California and the cases, the states out there is huge. So they've often talked about dividing that circuit, breaking it up into more than one circuit. Um, Also, if you have an option to file one place or the other, you may prefer to have a case go to a jurisdiction that handles a lot of those types of cases. For example, in the financial services industry, industry. You're going to want to be in Delaware or you're going to want to be in New York. And the Second Circuit in Delaware is in the Third Circuit. Delaware, New Jersey, and Pennsylvania are in the Third Circuit, along with the Virgin Islands. So there are certain, there maybe, I wouldn't want to say they aren't created equal, but the nature of the litigation that parties are pursuing may encourage them to file, if they have a choice, one place rather than the other. But of course, courts can also grant a request for a change of venue. If they think that the majority of the people who will be affected, you may file in New York, but if most of the people being affected are in Texas, they may transfer the case to, and there's a basis for jurisdiction, they can transfer the case there.
Great, thank you. Let's touch back on this idea of judicial independence. What does that really mean in practical terms, and why was that something that was built into our three-tier system, especially considering what you said before, is that even though they are, and this is true for all the branches, separate, in some ways they are also built to be reliant on one another in certain ways. So can you talk a little bit about this idea of judicial independence?
Well, judicial independence, as you've said, it stems from the idea that the three branches of government have different responsibilities. The legislature, the Congress makes the laws, the court determines, the judicial branch determines what the law is, and the executive branch enforces the law. So, in a very simplistic way, that's the way it's divided up. But if the judges feel like that they are not free from pressure and influence by either representatives of Congress, from the executive, or from parties outside the government that may have the ear of these other branches, they may not feel that they may not believe that they would be able to make a fair decision based upon their understanding of the law and the facts. That you're entitled to be, there's no problem with being political if you're president or if you're in Congress. There is a problem, not to say that it doesn't happen, but there is a problem if, when you have a case before you, you are making a political decision. And the code of conduct specifically prohibits that. And it requires you to maintain the integrity of the court and to avoid any instances in which it would appear there would be favoritism. You're to recuse from cases where you have some personal interest. Um, and so if the judges are being asked to be held to this standard, but then they are being um, attacked for the nature or the holding that they do, when they in fact are just trying to say what the law is, then that compromises their judicial independence. I mean, and I would just add here that personally, as a bankruptcy judge, the law was amended extensively in 2005. I went on the bench in 2003. It was very unclear what the law meant. And we would have decisions, judges in good faith from a variety of different courts would come to different conclusions because, quite frankly, Congress doesn't always draft things really clearly. Sometimes the laws or the proposed legislation is drafted by lobbyists for particular industries or something, and it doesn't always all fit together. So that's why it's the job of the court to decide what it all means. And sometimes you have different courts coming to different conclusions. And that each court should be independent to make the most informed decision, the most well-grounded in the law decision that they can, and not feel like they're being pressured to come to a particular holding because some party um, is going to criticize them for the opinion that they've rendered, the decision they've rendered.
And do you think it's that? I mean, this piece seems really important because we hear sometimes, uh, especially in the political realm, we hear about sort of a philosophical difference between well, judges should only go by the letter of the law, right? Or sometimes judges are not just interpreting, they're making policy, right? And do you think a lot of that stems from the fact that like oftentimes these things just simply aren't crystal clear? And so, as you said, like the law has to be interpreted. It just, we know this here in Pennsylvania from like our election law, for example. There's a lot of
Right.
gray in
Yes.
that law, and we
Yeah.
all live the consequences of that. And that's often why we see the courts at various levels making decisions every, cycle that affect ballots and what have you. It's frankly stems from the fact that that law is unclear, and the legislature to date and the governor have not taken steps to clarify some of those things.
Right. Right. Yeah, well, there are ambiguities in the law sometimes. There are differences, the Constitution is very spare, for example, and sometimes the statutes are spare or at least ambiguous. There are a couple of different philosophies for, this is more Supreme Court type of approaches. There have been justices who try to look to what the purpose is, and then there are justices that believe that you should look at the text of the law. And so at different times, the majority of the court has followed one particular philosophy or the other. Um, in some respects, for those of us who are at the lower level, we had to be told, and we were told by our circuit that this is the way you approach it. And because of when I was on the bench, because of the emphasis on textualism, that you look at the text, that is the way, even if I didn't personally agree with that, I may think, oh, I should look at the purpose of this legislation. That was what I followed in order to determine if what legislation or what a law meant. And there's a lot of very arcane descriptions on how you do that. You first look, is it clear on its face? It's not, it's the context. Then if not there, you look at similar laws. There's this whole rubric of how you make the decision on these things. So, but it's anytime somebody doesn't like the decision, they can always say, well, the judge is making law. Uh, and that's one of the reasons why we have the circuit court and the to give some continuity within the states within the circuit, and then the Supreme Court generally, if one circuit makes a decision one way and another circuit makes a decision another way, those are the kinds of cases that go to the Supreme Court because you don't want these different approaches um, to a particular law, and that's the reason they're there, and that's what they should be doing is clarifying ambiguities in legislation.
That's a good lead into to the next question. We got this from some folks in advance, wanting to know kind of within the system, what mechanisms are there to ensure accountability? And I think these came from kind of two different perspectives. One is sort of the system of checks and balances in terms of the appellate process. I think the other came from a point of view of sort of individual judges, codes of ethics, things we've heard about at the Supreme Court level a lot in the
Right,
past few
right.
years. Um, but to some extent, I think confusion or um, from some quarters, concern um, that sometimes it doesn't feel like there is a whole lot of accountability sort of at the end of the lane. Can you talk a little bit about all that?
Well, there is no enforced code of conduct for the Supreme Court. It it just doesn't apply to them. For other judges in the federal system, there is, and there have certainly been judges that have been disciplined. You can a party if they feel like that, for example, that you should have recused yourself and you didn't, that there have been judges that have been impeached for taking bribes. I mean, things like that. You can file a complaint with the Court of Appeals, and the Court of Appeals will look at those and investigate them. I mean, I can tell you, I had three filed against me in my tenure. They were all dismissed summarily, but I had to respond. I had to respond to the complaints that were filed. Um, so, some of them were kind of wacky, but they still were taken seriously by the Third Circuit and were investigated. And I think that's probably true of most judges. So, um, I think it depends a lot, circuit to circuit, as to how much they pursue that. And um, I think being eccentric is probably not something you're going to get disciplined for, but doing something that impairs the your ability to issue a fair judgment certainly should be a basis for discipline and for removal.
You touched there on your term, so I want to kind of just take a slight detour and ask, in your time with the court, what was the case you found to sort of be the most interesting to you, one that stood out, just for whatever reason you, yeah, found it to be, particularly
Well,
challenging or interesting.
this is a very easy one because the city of Harrisburg filed bankruptcy in 2011, and very few jurisdictions had done so at the time. And so, we pretty much don't get a lot of attention in the middle district very often. And I was totally unprepared for the interest in that case because we, all of a sudden had Reuters and New York Times and whatever coming down to sit in on court hearings. But it was an interesting case because for me because it was something that was very heartfelt, that this was needed by the city. There were certainly, again, there was this plea of help us, and you have to go, I have to see what the law allows. And the state was saying, no, you can't file bankruptcy. And, it was pretty clear that if the state didn't authorize it, they couldn't. But I had to investigate both U.S. constitutional law, Pennsylvania constitutional law, bankruptcy law. It was a very interesting case. They did end up in Act 47, which is the state rehabilitative program. But it was an interesting case intellectually, and it involved a lot of the community and a lot of different um, parties within the greater Harrisburg community.
Right, it's interesting. Yes, if you Google Mary, that is the story that comes up is the Harrisburg case. I want to go back to
Please don't believe everything that you saw in that story done in the in the newspaper. It was bizarre. Well, that's one thing too, and I would say, I would never give interviews. My opinions are what I say to the press. I had strict instruction that the clerk's office, other than to provide access to pleadings and opinions, were never to speculate about cases. So, as a journalist, I'm sure that can be frustrating, but I did not feel that was the case should be tried in the press, as they say.
Uh, s- since you went there, I'll just take this chance to ask. Um, as we mentioned at the top, you are a big supporter of Spotlight PA, and you and I have talked a lot about the importance of um, free and fearless journalism, and particularly the work we do. But from your perspective as a judge, and given that you didn't have many of those interactions, I'd be curious to hear kind of your take on the importance and role of the press and media, either as it relates to coverage of court issues or just generally.
Well, I think it's we have so much disinformation, misinformation circulating. I think news sources and we have such a shrinkage in local news coverage over newspapers, as you well know, the local newspapers have disappeared. And if things are very involved, they just don't have the staff to be able to cover them or investigate them. Um, yeah, I mean, I think it's critical to have avenues for people to find other than going to Facebook or Twitter or I mean X or whatever to find out what's going on. And um, it's very difficult sometimes to not get caught up in a lot of uh, repeated misinformation and disinformation about what actually occurs in the world. And I think the sources that are well vetted um, sources are really important.
Um, Someone asked in advance what um, power judges or the courts have to sanction or keep attorneys in line. And the main premise of the question was for those that may be submitting um, sort of inaccurate briefs or briefs that are citing cases that don't exist, or maybe briefs that are being written by AI citing cases that don't exist. So I guess in general, the sort of like, um, yeah, what power do judges have to make sure that those pleadings and those documents and the sort of overall discussion, like the discussion of the and debate of the case is based in reality and fact?
Yeah. Well, I'm very glad that I was not on the bench when AI wa- became a big factor. But that's not a new problem. Misrepresentations in pleadings, misrepresentations in briefs, both as to the law and the facts. It certainly occurred during my tenure. Uh, if if a party and there are a lot of other reasons that attorneys can be disciplined. Neglecting their clients is probably the most often reason that they're sanctioned. But for misrepresentations, when you sign a pleading or you advocate for a position in the court, you are verifying that you've made an investigation, and to the best of your knowledge, these things are true and correct. In addition, you're also verifying that when you're asserting a legal position, that it's supported in law, or there's a good argument that if that hasn't been decided, that it could be a rule of law. So there are, and this is rule 11 of the rules of civil procedure. Um, so it gives the court an opportunity if these matters are brought to the court's attention. Sometimes the requests for sanctions are filed by another party in the case, but the court can also, sua sponte, on their own, um, sanction an attorney. But there are a lot of procedural hurdles. One of the things we're cautioned to do as judges is to be patient, is to give people a chance to do the right thing. Um, and I know in my experience, you generally want first to to call them on it to say, this is not supported by the evidence in the case if it's a fact, or this um, this legal position you're taking is not supported, and you have a case supporting it, and that case doesn't say that. I want you to file an amended pleading, or I want you to amend your brief, or whatever the document was that you filed. You first give them a chance to make it right, pretty much. If they don't make it right, then you can file a motion for sanctions. Um, and if then they give them an opportunity to respond to that. Eventually, they can be sanctions monetarily. They can be held in contempt, and if it's really bad, can be either civil or criminal contempt. Um, but it's basically the same rule for parties as for attorneys, but we always held attorneys to a higher standard since they are officers of the court. So yeah, there are a number, but it's the last thing you want to do. You really want to avoid spending a lot of time sanctioning attorneys. You want to move on to the substance of the case. But I know we've certainly seen examples where it's been very frustrating, where there's been repeated misrepresentations or defiance of court orders. That I never had an attorney do that. I had parties do that, and a couple times the marshals were going out to arrest him and take him to jail before they turned over property of a bankruptcy estate. So sometimes with entities, you have to take it all away to the end point of them being arrested and taken to jail. But generally, you want to try to avoid that. You want compliance. You don't want punishment. That's the philosophy anyway. Yeah.
So you mentioned the marshals again, so I want to circle back around to this. Number one, can you just clarify for people where the U.S. Marshal Service is based within the government? Number one.
Well,
We'll
it's
start there.
part of the Department of Justice. It's within the Department of Justice, and it is like a law enforcement agency. So that doesn't seem inappropriate. And in fact, it worked very well for a long period of time, because the courts have, I don't want to say closer, but more frequent contact with a lot of elements of the Department of Justice. For example, on the criminal side, they're the prosecutors. Anytime there's a criminal case, the U.S. attorney is in there. And not him in particular, he or she, but somebody from that office. So there is a pattern of regularly having members of or attorneys for DOJ in court. The U.S. Marshal Service is, I assume, I don't know, the origins of it, but I assume because it is law enforcement, that they are within DOJ because it's a law enforcement agency. But it is their responsibility under the statute to carry out, to execute the orders of the courts. So they're mandated under the law to obey the judges and to do what the judges tell them to do, but they are into the same department that maybe they're going to be enforcing against the same department. Now, that is not unheard of. With it, when I was with the Office of the United States Trustee, which is a component of DOJ, um, we were responsible for supervising the administration of bankruptcy cases. Sometimes I would be taking a position that would be at odds with the Department of Agriculture in a case. They had a claim in a case, and I'd be wanting the case dismissed. And Department of Agriculture would be wanting to have the case stay in bankruptcy. So there are these Chinese walls in some way between different components of DOJ, and that, that has worked in the past. I think the problem now is because there's such a close tie between the U.S. Marshal Service and the courts, and that they are responsible for the safety of the judges. It's sort of a unique situation. Now, I know there have been some proposals. I think Senator Booker has proposed moving the Marshal Service. I don't know if that would get any traction, but I mean, I see if it's within the courts, then you you may have a conflict there because you have an entity that you're working with that's basically a law enforcement entity. I mean, they've had the same issue when they've talked about if the government won't pursue an action, the court can appoint a private attorney. Well, then does that make the court invested in what the private attorney's doing? So that's where these connections between the three branches get very murky, and it's hard to come up with what's clearly the right answer. But I can understand the concern of the judiciary and the administrative office of the U.S. courts um, about whether there may be a change in the willingness of the U.S. Marshals to operate in the same way that they have in the past.
Yeah, I think that, brings us to something, and Katie in the chat asks about this on everyone's mind of just like, okay, if we get to the point, or maybe, you know, maybe we're already at that point, where judicial decisions all the way up to the Supreme Court are not being followed, um, sort of where does that leave us? And I know you hear a lot about uncharted water, constitutional crisis. Um, and I know you don't certainly don't have the answer, but
No, I
um,
don't.
but how, I
Yeah.
guess if we can get anywhere, just like how can we help people think about this issue that keeps getting bantied about everywhere?
Well, think, and I think people are beginning to, a lot of people, there's obviously part of the problem in the country is the polarization of the country and the fact that a lot of the guardrails for democracy are down. We talk about that, the lack of democratic norms, that, this lack of faith in the rule of law. To go against that tide, one thing is that the public needs to understand and support what judges are trying to do, not necessarily support every decision. They may oppose it. But like for example, it's always been it's been our history that even when the Supreme Court ultimately ruled against uh, Congress or the president, they accept it. They don't say, "Well, I'm going to go ahead and do what I want to do anyway." I mean, I think a good example is in Bush v. Gore. Gore accepted the fact that he did not win the presidency. Um, President Bush also had a number of the actions that, in regard to detaining people in Guantanamo, that the Supreme Court uh, ruled were unconstitutional, and he didn't agree, but he decided he needed, because that's what the court decided, he would live with it. I think that that people need to understand that, and the court may not be right, and I certainly, as an individual, don't always agree with what the Supreme Court decides. But I think that we have to understand that we have to act on what the final decision is, and accept it and try to find, if we don't like it, other ways to address, the issue. And it's
Um,
not, it's hard to know what that is, but I think giving up on our system is really not a good strategy, you know.
sure. um, we have about 4 minutes left, so I'm going to end with these sort of two-pronged question. Number one, and we've heard from folks, can you suggest some nonpartisan sources that people maybe can follow to stay informed about the court system and what's going on? And then the second part of that is, um, what can ordinary folks do if they're, concerned about the independence of the judiciary or um, anything else kind of related to it? We have a sense of what responsive mechanisms look like for the executive branch and for the legislative branch, but people don't have as much sense of what that looks like from a public perspective for the court. So anything you would suggest for folks on those two fronts?
Well, I think that, you know, uh, kind of responding to attacks against the court in a way that's, don't pile on. Let's put it that way. Push back on these demonization of judges, and make it clear, when you contact your representatives in Congress, that you don't approve of these approaches. And I think that's one thing that we can do, is that you need to stand up for the courts, because one thing is the courts are not very good. We don't really have the tools to stand up for ourselves much. If you notice, the Chief Justice will rarely come out and say anything about the way that judges are being treated. It's really almost, our defense is left up to the public, to attorneys who want to maintain the system, and they've been some of the strongest advocates. Um, the American Bar Association certainly has attempted to support the judiciary, and local bar associations. In terms of, um, right off the top of my head, in terms of places, I think I had discussed with you a little bit about some places where you might be able to find information about the courts. One is the Administrative Office of the U.S. Courts has a website. The Federal Judicial Center has a website that provides explanations of how the courts operate, and actually even resources for teachers and for those who are trying to educate people about the role of the courts. Um, there's actually website called GovInfo, GOVINFO.gov, that has a lot of information about the courts and has court cases that you can look at. Those are also good sites. Um, I think Spotlight has done a lot of work on the local courts, and some of the media has tried to focus also on the federal courts, but we don't really have the same sort of focus that I've seen at the national level. There's a report on individual cases, but not overall as much on the court system. The Brennan Center also has an excellent website upholding the courts and the rule of law. There is, one thing I wanted to mention is there is now a group of retired Article 3 judges. So these are mainly district court judges that have formed the Article 3 coalition, and there are 30 of them, and they're trying to promote and support various groups, education groups, or advocacy groups that are defending the courts. It's within the organization called Keep Our Republic, and you can go to Keep Our Republic. Some of the members of Keep Our Republic are individuals who've been involved in government or are concerned about the erosion of democratic norms. And this subset within that, the Article 3 Coalition, is a group of 30 retired Article 3 judges that have been actively supporting measures to get the word out about the need for support for judges. They're no longer on the bench, so then they can speak out more than those who are on the bench.
Great. Well, we're at time, but I want to thank you, Mary, for a really fascinating, enlightening discussion. I know I learned a number of things in our hour, as I always learn from you when we have time together. So I want to thank you, not just for this event, for your time serving all of us as part of the judiciary. Thank you so much. I also want to thank everyone who attended tonight. We had a great turnout. And again, you all make this work possible. Your support now, your support in the future, makes it possible for Spotlight PA to do all of our investigative and public service reporting, but also to platform important discussions like these. So I want to say thank you to all of you who are here tonight. And as I always say, this is always the start, not the end. So please go on, continue the conversation, talk to family and friends, continue to learn and consume quality information. And we hope to see you here back for our next discussion. Thank you so much, Mary.
Now, thank you, Chris.
Have a good night.
Okay, good night.